Yeah, we shall start, sir. And your cam is off now.
Hello and good evening to everyone who has joined here. And there is a live Twitter Spaces feed also happening. I'm also turning it on. So, welcome to CiteCase Club. This is the first ever event of CiteCase Club, which is nothing but a group of people, group of lawyers, law students, and common citizens of this country who will be discussing various legal topics, judgments, etc. So first I have to introduce myself. I am Ashokini. I'm a lawyer practicing in High Court of Kerala. Uh, now it is in mid 2021 I started Sidecase as something to help professionals like me, legal professionals like me, to have a knack at case law research. So this happened, I believe, in July 2021, and I started a Sidecase Twitter ID, Sidecase Gmail ID. I took a domain name sidecase.in, and then I started tweeting in Sidecase ID. Thereafter, one fine morning, I said that I will help anyone who will seek any assistance regarding case law research. That tweet went quite viral, and then followers started pouring in, and now we are at 8,000 followers strong. So this is the beginning of Sidecase, and it is 1.5 year long journey. And we have this year started a website, sidecase.in, where we will be posting the answers to our queries, answers to the queries we are getting. And this year we thought of starting this club also, and that is inspired by Mr. Arun Kumar, who is a law student from Tamil Nadu. He started a YouTube channel where he's discussing various legal topics like those provisions in CRPC, and also the judgment in Lalita Kumari, etc. So we thought, why not we also start doing this? Let us also start discussing judgments, not to judge the judgments, but to learn from the judgments. That is the focus of this club. We are not going to judge whether a judgment is right or wrong. We will point out our views regarding a particular judgment, but we will not pass judgments on judgment. This is not the focus of the club. There are other places to do such things, but our focus is to learn from judgments and learn from discussion about these judgments and laws. So now I have told about myself, I've told about beginning of the side case, and now we should move to the first topic, demonetization judgment. This session, 1 hour long, we hope it would be, is not about merits or demerits of demonetization. We are not judging the demonetization by what happened later, but we are only discussing demonetization, how it was dealt by the Supreme Court, by the majority judgment as well as the minority judgment parts of it, how this came into being, what is the background of these petitions, how this came to the constitution bench, etc. That is the focus of this session. As we all know, demonetization is connected to most of us. We have been in one queue or the other as a result of demonetization. I still remember I was only a 2-year-old lawyer. I was only I started practice only in 2015, 2014, and I started going to office as an intern. Then 2016 November, I was only a 2-year-old lawyer. Then at that day, we had to go to the office, and at about 7:30 we would return home. That day, 7:45, as usual, I returned home and waited for the bus. And then I took my Twitter and saw that Prime Minister is going to come live on TV for saying something, we don't know what. Then I entered the bus. Bus was full of people. We could not, at those days, we could not sit because of the rush. So I could not check the Twitter live. But after perhaps 8:20 p.m., 8:20 p.m., I took the Twitter and saw that the money in my pocket, which I just received from my senior as part of the fees for the case which I assisted him, is no longer going to be a legal tender from 12 p.m. that night. So that was not much fees. Do not misunderstand me while saying this, but still, that was the effect which I felt when I heard the Prime Minister's speech. The perspective about Prime Minister's speech, or whether it was good or not, that is not the focus of uh, this session, as I told you earlier. Now, just like me, there were various other people. There were various other people who felt some difficulties post the event, post 8 November 2016. And some of them went to the Supreme Court and challenged this demonetization policy on various grounds. Ultimately, this matter was lodged in 2016, and it was, in fact, admitted. Writ petitions were admitted. It was later referred to the Constitution bench because there were a lot of issues involved which had wide repercussions. So ultimately, the Constitution bench heard last year. There was a pressure from the center to dispose of these repetitions as infructuous, but the case was heard quite on merits. And finally, as a New Year gift, I would say New Year gift to government, this demonetization judgment came, and it was quite upheld by the majority of the judges. One judge, Justice Nagaratna, dissented from the majority judgment and said that it was legally wrong to do so. But she said the intention was good. Majority did not go into the intention of the government, or did not say that the intention is good or bad, or it was quite intentional or not. It was not discussed in the majority judgment the way in which the minority judgment last paragraph has dealt. So overall, this judgment in a way upheld demonetization. The repetitions are not yet disposed of. Individual cases remain, and it is referred back to the 3 judges benches. And now, more about this judgment, like the piecemeal part of it, we will expand it one by one after Mr. Arun Kumar, who is a final year law student from Tamil Nadu. He has prepared the summary and also the piecemeal analysis of the judgment. So he will be continuing with this, and he will be interacting with me. And finally, we can you can express your views also. Other listeners can also, subject to the availability of time, we can let you offer your views also. So I am passing over the mic to Mr. Arun Kumar.
Thank you, sir, for such a wonderful introduction. And good evening, everyone. And I would like to thank you all for taking your time to join us, to join this new venture. And I would like to begin with expressing my profound gratitude to the CiteCase founder, Mr. Ashok, for creating this wonderful venture. As a student of law, I'm sure many of you can associate with this feeling. We always ache for opportunity to talk about law, to discuss law, to discuss with someone who is as interested in the topic as we are. And this venture is exactly tailor-made for that. And I'm sure that this endeavor, this venture will reach great heights, and I will be glad to be part of it while it does. And it's a double joyous occasion for me for one particular reason. The topic that we have chosen to come on, to kickstart this event is very unique and special, because the facts of the case are so contemporary. As Sarah has wisely pointed out, and he has even given his personal experience, many of us have a personal experience with the demonetization. Although we have many of us have read a fair number of judgments, the facts of demonetization is so relatable because we lived during that time and we lived through demonetization, if I may say so. So whenever the facts is narrated in the judgment, it's so relatable to me. I'm sure anyone who reads the judgment, can relate to the facts. So the facts has been clearly, given an overview by Mr. Ashok. So I will not give, owing to the paucity of time, I will not much dilate upon the facts. I will just give a legal aspect of what happened then. Demonetization involved two elements. One, when the Honorable Prime Minister announced, notification was issued by the central government. And that notification issued by the central government by the power drawn by them through the section 26, subsection 2 of the RBI Act. So what is that notification? The notification states, on recommendation of RBI, a central board, the government can make certain denominator, certain currency cease to be a legal tender. And if my understanding is correct, that notification merely makes those currencies cease to be a legal tender. Legal tender is nothing but an instrument of payment. When we want to buy something, we use a currency as an instrument to make a payment. So that notification serves that purpose where it no longer be legal tender. But if I add a 500 rupees, then the value of the 500 should remain the same, right? Because section 34 of the same act, RBI Act, fastens liability upon the RBI, a issue department, a part of RBI, that department is liable for all the currency in circulation. So if I have 500 rupees then on the night of demonetization, it merely ceases to be, if my understanding is correct, it merely ceases to be a legal tender. But the value should be same, and the RBI's liability to me for 500 rupees should remain the same. So what government did is, they promulgated an ordinance, which eventually became an act, cessation of liability, specific banknotes act, where they have terminated the liability of RBI, where they have seized the liability of the RBI. So the two element is, government seized the 500 and 1000 rupees note, all series of 500 and 1000 rupee note as a legal tender, as well as through the ordinance, they have seized the liability of the RBI. The ordinance is not called into question, so that won't be a part of our discussion. It's not part of our discussion. Our discussion, owing to, on account of brevity, there are many contentions raised, as Sir said, but there are four major contention which virtually covers the entire judgment, and we will just stick to the four contention. The first contention, in my view, the first contention is the art of this judgment, a kernel of this judgment, center of this judgment, center of this controversy. Because the rest of the issues arise out of this first issue. As the court decided in favor of petitioner, here the petitioner who opposed the demonetization, for the sake of understanding, I'm simplifying it, and the other one we call it as a government. As the court decided in the favor of the petition in the first issue, the rest of the issue wouldn't have arisen, it would have become infructuous. So the first issue is very crucial here, but ironically, the first issue is very simple to understand. It's very clear, and there's no complexity in it. So what is the first issue? The Act says, I'm just the putting forth the substance of the Act. On recommendation of RBI, the central board, the government can choose to pass a notification which can seize any series of any denomination. Here, the word "any" before series is the center of bone of contention here. In simple terms, let's say that for 500 rupees there are four series: Series A, Series B, Series C, Series D. So the act says the government can, on recommendation of the RBI, make any series of them that either A, B, C, or D to cease to be a legal tender, that they will no longer be a legal tender. That's what they say. Any series of any denomination. Any denomination, no problem at all. They have not taken it as an all denomination. But here, the any series, the government issued a notice through the power drawn from this subsection, where the any series is taken as all series. All series means at a single stroke, they have, for in this example, at a single stroke, they made A, B, C, D, all series of those denomination cease to be a legal tender. So the act says any series, but the government have interpreted the act and acted based upon the interpretation that the any means all. So we are in a single notification, we are going to cease all those series to be an illegal tender. And this was the center of contention. The petitioner raised, the argument of the petitioner is, how can you take any as all? The statute says any. That is not all. If the government wanted to, the government does have power to, the legislation does have the power to demonetize all, but they should have chosen the path of legislation. An executive order cannot be issued in this fashion, where all series, not any, all series of a particular denomination can cease to be a legal tender. And the logical argument they made is that if that interpretation is accepted, then a series of note issued the very previous day of the denomination will cease to be a legal tender. So if demonetization is announced today, a series of note which was issued yesterday will cease to be a legal tender. That's a bit irrational and illogical. So that couldn't have been the interpretation the legislation would have intended. Then number two, if indeed the any means all, if that's true, then this particular subsection becomes vulnerable to be struck down on the ground of excessive delegation. The delegation, many of you know, where legislation delegates certain power to the executive to exercise on their discretion, because every details can't be gone into during the enactment of an act. So the delegation happens, but here, if such a wide power has been given to the government on account of this particular interpretation, then this particular section will be vulnerable to be stuck on the ground of excessive delegation, and that will be the subject of our next contention. But the petitioner stated that a law cannot be interpreted in a way where it becomes unconstitutional. So the law has to be read down. Interpretation should be given, should be read down. The stretch of the law should be read down so that it still be constitutional. It does not get stuck down. So that's the point number two. And then the government defended, as usual, stated that the any can never be, any can certainly, any means all. And what are the point of the government, the argument of the government I find very convincing is that we have power, even as per the petitioner, to demonetize, to issue notice for each series. So if you decided to issue notice for A series, B series, C series, and D series separately, then we can cover all the series. So when we have the power to call the to cover all the series through different notification, then wouldn't it be illogical to say that we can't do it at one notification? So the word any certainly means all, according to the argument of the government, and the court agreed with that, and the court gave slew of judgments supporting where the any means all. In fact, court has gone to the role of RBI and the power of RBI, and where the importance given to the RBI, and the court has sought the assistance of purposive interpretation. Even the literal doesn't say that it can't be any, but literal interpretation can't be given here. That's a basic rule, the literal interpretation, but court has gone to the purposive interpretation, which means that the entire scheme of act is studied, the intention of the legislation to the preamble of the act, to various other sections. So this particular subsection is interpreted keeping in mind with the purpose of this entire act, which is the RBI Act 1934. So by purposive interpretation, court has stated that, interestingly, any means all. There's a very interesting factor which I will raise it with with Ashok sir at the end of this video. But as of now, we'll keep it simple. But the court stated that any means all. So that contention of the petition is dismissed, but it is favored towards the government. The next, the petitioner, the contended is, okay, any means all. So the government in a single notification can include, can seize all the series of a particular denomination to be a legal tender. So this is an excessive delegation of power upon the executive from the legislature. The legislature is sort of an abdicating its duty. Such power, such an excessive power without any safeguard, will certainly lead to arbitrariness by the executive. And please keep in mind, a legislature, technically, although the leading party in the legislature becomes the executive, but there is a distinction between both those two, where the legislature or people elected by the people elected by the people of this country. So a law has to be passed only by the legislature, and delegation can be made, but not to this extent, not to this magnitude. So according to them, there is no proper safeguard, and this kind of interpretation where any means all will lead to an arbitrariness, and they claim that this action itself is quite patently arbitrary. So it should be struck down on the ground of excessive delegation. And the court analyzed, and in fact, the petitioner has cited many judgments to buttress his argument, his view, where a delegation made without any safeguard, and that particular provision is struck down on account of excessive delegation. There was various judgments which the petitioner cited to buttress his side of argument. Then the court went through. There are two important factors here. One, this action cannot be taken by the executive government on their own. This can be done provided two conditions are satisfied. One, there should be a recommendation by the central board, RBI. Number two, the executive government should accept that recommendation and act upon the recommendation. Only when these two conditions are satisfied, then this action can be carried out. So the court goes into a part by part. One, what is RBI? The importance of RBI. The RBI has a very vital role to play in a monetary policy of this country. And the RBI has a very vital role to play in regulating the currency of this country. RBI consists of a team of experts. On the other hand, the delegation is not made to some mere government department, but the highest executive authority of this country. The executive authority which is answerable in the parliament, the executive authority which has to go to the people once in a 5 years to seek their vote. So the act says recommendation of the RBI is mandatory. So that is a safeguard. That itself is a safeguard. That itself acts as a check and balance for any arbitrary action. That will prevent any arbitrary action. Because without recommendation of the RBI, the executive cannot carry out this particular function, cannot invoke this power, cannot issue this notification. So the recommendation of an expert, the not an ordinary bank, but a banker's bank, is mandatory. So that itself is a safeguard. And again, the power has been conferred upon by, on not some normal government department, but the highest executive authority. So it cannot be treated on same foot with the other cases where there is a ruling in favor of excessive delegation, stuck down on account of excessive delegation. And the court also says that we have to be pragmatic in this matter, because the legislators are not expert in everything. They're not expert in the field, expert in that subject, and the legislation cannot possibly go into all the relevant factors while enacting that particular act. So while implementing the act, the executive will certainly face new problem which wouldn't have been contemplated by the executive then. So the delegation is necessary, provided there is an inherent safeguard within the delegation to check the arbitrary exercise of that delegation. And here, the safeguard is by none other than the RBI, the highest bank, the bankers' bank, which regulates our currency. So it cannot be stuck down on the ground of legislation on this ground. The next contention, in fact, this contention is very interesting because I have earlier stated that to carry out this action, two conditions necessary. One is recommendation. Again, that RBI should recommend that this action to be carried out. Then the government either accept or reject the recommendation. But here there is a slight digress in that procedure as stipulated in the act and in the provision. Here, RBI didn't recommend on its own. There was a communication sent by the government to the RBI, Central Board, that these are the factors, such as, there is black money and terrorist funding and other objectives. So we think it would behoove us to demonetize these particular denominators. So the central government expressed the desire to the RBI, but of course the RBI is independent to take the decision. Central government cannot pressurize there. The RBI could have just read the letter and said, no, we do not think that this action is necessary, so we are not going to recommend it. The RBI is well within the right to say that. They have the power to say that. But the RBI considered those and made the recommendation. And the central government acted upon that. So the argument made by the petitioner is that, in fact, there is another thing here. The scope of judicial review as well as involved here, as expounded upon in this part of the judgment. A judicial review cannot question the wisdom of a decision. Either decision is good decision or bad decision. Decision means policy here. All they can see is the legality of the decision. So the petition made a point that we are not seeking the court to question the wisdom of the decision, but the way the decision is arrived, if that is flawed, then that can be questioned. Because the act stipulates the procedure how that decision should be arrived. That it should begin with the recommendation of the RBI, then the government should act. But here, the government sent a communication to the RBI expressing their desire to have this action carried out. Then the RBI made the recommendation. So the petitioner argued that that itself is flawed. So it should be stuck down on that ground. Addition can't be questioned. The judicial scope, the scope of the judicial review is limited there. Particularly in the monetary policies, did not go much into it, as stated by the Honorable Apex Court in this judgment. But the manner they have arrived at the decision, if that is flawed, then that can be questioned. So instead of RBI recommending on their own, the communication sent by the central government probably caused or stimulated to make that recommendation, but they are independent. They could have very well said that we do not want to recommend it. This is where the court analyzes it very interesting, but very pragmatically as well. My art leans towards the explanation given by the court personally. The court says that, we can't give such a narrow interpretation to this. For one reason, the RBI is only concerned with the monetary policies. They do not have any other concern there. But the central government has various other concerns. They are concerned about the law and order. They are concerned of the security of the nation. The terrorist front is being made because of these currencies. There are a lot of bogus currencies, or because of this black money. Then that's a concern of the central government. RBI won't be concerned about that. So if a central government decides that this action to be carried out, demonetization should be carried out, there's nothing wrong in them saying to the RBI, and the RBI independently applying their mind and making a recommendation. So the judgment interpreted the word recommendation as consultation. So there's nothing wrong in that. Central government consulting and then RBI making a recommendation, there's nothing wrong. So it's a very interesting part is that a recommendation word is given a meaning as a consultation. So this ground also, goes in favor of the government. The next one is also very interesting. In this one, I have to personally admit that I find the petitioner's argument very plausible, very convincing, which is doctrine of proportionality, which means action taken to achieve some object should not be more than necessary. To simply put, should not be more than necessary. So what happens in this case? There are four rules, for the doctrine of proportionality. One, there should be a proper purpose, proper objective for a particular action to be carried out. Here, what is that objective? Black money, bogus currencies, and so on. So first condition is there should be a proper objective. The second condition is that the action taken to achieve that objective should have a rational connection, should have a rational nexus with that. We can't say one objective and say doing some action totally irrelevant to that objective. So there is an objective, black money and so on. So the action, which is the demonetization, should have a rational connection with that objective. So the court says that there's a rational connection there. The third one, it is the most important one. If there is any alternative efficacious method available, where there is the same objectives achieved, but the restriction is not as severe as this one, then that method should be chosen. In other words, to achieve the objective stated in demonetization, if there is any other alternative method available to achieve that objective without being so excessive as demonetization, without being imposing such a restriction as the demonetization did. Of course, it imposed a great lead of hardship. It's admittedly no doubt about that. And the hardship is quite palpable and is very ubiquitous across the country. But the objective in the perception of the government is so superior that we have to bear the hardship. They not say that you endorse the hardship, but we have to bear it for the larger good cause. We are not going to get into that. So the third rule, this is what the petitioner strongly relied upon, in my opinion, where this action is so excessive to achieve that objective. The court simply said that it can never be said, it can never be defined. Whether there is alternative method can never be defined. We are not experts. That's true. Now we can say that demonetization caused this problem, that problem in hindsight. We have the benefit of hindsight. So we cannot judge a decision taken with the benefit of hindsight. So the court says that it cannot be defined at all. So that ground goes away. The fourth rule is simple, where if you go to the Constitution 19 clause 6, where restriction imposed for the public good, but there should be a balance in that. In this current facts, there must be a balance between the public good and the suffering imposed upon the restriction imposed upon the people. And it passes the test here as well. There are other contention, but those are very incidental to it, and I think this measure covers the entire judgment virtually. So on all the four issues, the majority judgment favors the government. As Mr. Ashok said, they didn't comment upon the wisdom of the judgment. They didn't say that whether the demonetization is good or bad. They exercise a great deal of restraint in passing any comment upon that. But the dissenting judgment, the ladyship, in fact, the first contention is said that it can't be the any can't be all. So the matter gets settled there itself. She said that demonetization is good and they had a very good intention. Only the route they have chosen is wrong. They should have gone through the legislation. Schedule 7 and I think entry 36. So the dissenting judge, which invalidated the demonetization, said that this is a very good policy. Demonetization is good. But the majority judge, which upheld on the following grounds, didn't comment upon the wisdom of this policy. And with this, I conclude the summary. This is the entire conspectus of the judgment. Of course, with this time, we can't go much detail into the judgment. And I would like to ask Ashok sir one thing. This is very interesting. In the first contention, in an effort to validate the demonetization, the court has surprisingly said that any means all. That even I have read it, reread it, they say that any would mean all. So if my understanding is correct, they mean that any should always be taken as all. In that, haven't they restricted the power of central government and the RBI by stating that you cannot demonetize a particular series of a denomination? You have to demonetize all series of either all or you can't demonetize. How do you address that, sir?
Thank you, Arun, for this wonderful summarizing of the judgment. You have put it very well in the sense that you have covered all the issues and the answers of the court as well as the petitioners also. Before I come to your question, I would like to give you another picture of this. In fact, the Constitution Bench judgment was live streamed in YouTube, as you might have watched. Many of you might have watched that also. In the earlier part of the hearing, Central Government Attorney General, he said that there is nothing to be discussed in these cases because everything is acted upon. Demonetization is an old story. It is every banknotes have been exchanged, and there are minor issues that can be dealt by the smaller benches. There is nothing for the Constitution Bench to say anything about this. At that point of time, there was a discussion among judges. Thanks to live streaming, we know how these things happen. As a lawyer in High Court, I have not ever seen Supreme Court hearing a case, but thanks to the technology, we know how these things happen in Supreme Court. So the judges discussed them among themselves, and there was a senior advocate, and he was also finance minister of the country in the UPA government before 2014-2012. Chidambaram, senior advocate Chidambaram, he then argued the matter. He said it is not infructuous, and that argument was very, 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 very beautifully made, according to my opinion, that convinced the court that there is something in this matter which is yet to be adjudicated. It is not like simply put by the Attorney General infructuous. There is something more to be looked into. And this went for, I believe, 3 or 4 days of arguments. There were both sides of arguments. So one argument that Chidambaram, senior advocate Chidambaram made was that this is not the first demonetization ever. He said in 1946 there was a demonetization when it was under the British regime, and also in 1976, I believe 1976 or 77, there was another demonetization, but that demonetization was done in a legislative route. So one of the issues was whether the previous governments or the previous regime acted in such a way, like acted in a legislative route with an intention, with a view that 26 subclause 2 does not give them power to, in fact, demonetize all the currencies, all the currencies of a particular denomination, like 500 and 1000, 500, all 500 and all 1000. That was not the understanding of the government. But the court said that if a government can do any, can demonetize any currencies, like you rightly pointed out, one by one it can be done. The example given in the government is that there are 20 series, and if the government has power to do 19, why not 20? The impact of the word any means all. See, you say that you can take any apple. It means you can take all apple also. You can take any apple in this box. If you tell a boy and he takes all things, can you say that it is a kind of misinterpretation of any? So instead of saying that, as you rightly pointed out, the court said any should mean all. I think in other parts of the judgment, it is not that strongly said about that. But I believe any includes all. That should be the spirit of the judgment. Any includes all, but any does not mean all. That would be a quite, I would say, that would create a lot of ambiguities. But at somewhere, as you pointed out, it said any should mean all, else it would create absurdity. There was some part of the judgment which says like this. Personally, I do not agree with that comment, but I agree with the majority view that any can mean all. Like if there are 19 series, 20 series, and 19 could be done with this any, 20 can also be done. That is the spirit of the judgment. But there is one sentence, as you pointed out, that can be read out of context in a future case. But spirit of the judgment is this. That is my opinion about that part of your question.
In fact, that's what I also felt, because that would lead to an other side of, for lack of better word, absurdity. But of course, the court wouldn't have meant that way. In fact, the earlier demonetization, the court particularly said that when this argument made, just because they are done that way, it doesn't mean that the power is deprived, denuded of the central government to do this way. And that's quite acceptable. Okay, I will go to the next question, sir, which is very interesting. In the argument of proportionality, they say there should be some object. The method adopted should have some nexus with the object. But do you think, I'm seeking a personal opinion, do you feel there is any vacuum where you feel the court have gone a little bit further to check whether the object and the nexus, and whether the action taken as is proportionate to the the object intended? Do you think that court has just said that we are not experts? We are not experts, so we cannot comment upon that. Do you think that court should have gone a little bit further? Do you personally feel that?
I believe so. That I agree with you in that aspect. There is a quite vacuum in that part of the judgment, like whether it was proportional. So many judgments are quoted with regard to the doctrine of proportionality, and it is said that sufferings, these kind of measures cause martyrs. Such kind of quotes were there, but substantially speaking, in the judgment there is no reasoning. It is my humble view also. There is no reasoning as to why it is not as you pointed out, there were other means to tackle demonetization, in the sense black money, there other than demonetization. So there is a vacuum in that part of the judgment, but ultimately court might have felt, that is my justification of the majority judgment, that court might have felt that it is not proper to go into those matters, because that will be like saying going into the area of experts. How can court judge that this method will be more proper to tackle demonetization or to tackle black money or not? And ultimately, we must remember, rightly or wrongly, in the earlier part of the judgment, the RBI power to recommend is there. Section 26(2) gives the power to RBI Central Board to recommend demonetization. And it has been done in this case. There is no case for petitioners that there is no recommendation. They are saying that that is an hasty process. RBI just did it in a like a master's call was there, and RBI just suddenly acted upon the master's call. That was the petitioner's argument. But majority judgment points out, and this is where the dissenting judgment lacks some substance. In the sense, I would put like that. Dissenting judgment says that there is a hasty decision, and RBI did not thought of the consequences of these things. As an expert body of economic policy, RBI should have thought what would have happened to the citizens, their difficulties, etc. This is not done properly in that 24 hours period. That is the reasoning of dissenting judgment. That is quite convincing to the emotional brain. But legally speaking, and also factually speaking, through the majority judgment, it's not my opinion, majority judgment says that there were 6-month-long consultation with the government. Here and there, the communication were going, saying that what would be the impact, etc., etc. There was consultation. That is what the finding is, factual finding is. We do not know how that factual finding is right or not, but judgment reasons it, saying that there is a factual finding that there is a communication, there is a consultation between the RBI, who should be recommending under 26.2, and the government, who should be notifying this under 26.2. So it doesn't matter that at one point of time, like on the previous day of 8th November, on 7th November, government requested the RBI to give a recommendation merely because that is the origin. That is the origin. Even if that is taken as an origin, this 26.2 interpretation would save the government. That is the finding of majority judgment. In that respect, dissenting judgment also reasons it in other way. But according to my opinion, it is quite an emotional approach. Like, how can this be done in 24 hours? Yes, that is a good argument. That is a good political argument. That good, like it's a social argument also. It makes the citizen the central point of policy. Ultimately, this is done being for the welfare of the people. And if there is no welfare happening for the people, then this policy should go wrong. That is the logic of dissenting judgment. And that in that angle, some of us might align with the dissenting judgment also. But this is what the court found in majority, and this is the truth now.
Yeah, in fact, the other side might have felt that since the government is sending a communication, the RBI might internally have felt pressurized. Maybe that would have been their genuine intention to make this contention. But RBI is an independent body, certainly wouldn't have got pressurized. And there is some inconsistency between the dissenting and the majority, where the majority says 6-month process. I mean, dissenting says that everything started with the entire process started with the communication to the government to the RBI, and everything got completed in 24 hours. But that looks less likely, because an action of this magnitude would have certainly taken more time. And what is known to us is what happened in 24 hours. They have not disclosed before, the 6-month consultation and all. So that would have been the reason. And the third one, I will, very briefly, very lighter one. How do you feel that the dissenting judgment applauding the policy of demonetization, while the majority cautiously refrained from passing any command upon the wisdom of the policy?
In fact, that is a quite political question, in the sense like every judgment of the Supreme Court nowadays are divided into two. One will laud the judgment and another will bash the judgment. That is what is happening nowadays. So majority giving a judgment in favor of government will be seen as an extension of executive thing, and the minority will be applauded, as you said. So in this case, curiously and interestingly, Justice Nagaratna's judgment elaborately discusses all this point in favor of petitioners. And finally, she says that the intention of the government is not questioned. She is not questioning the intention of the government. It is for fighting the black money, terrorism, etc. And she ends this judgment with this note. She's saying it is legally wrong, but the intention was good. So if you like a simple mathematics, there is a 4:1 judgment. This four judges did not quite touch upon the intention. They said here and there that sufferings will not make this bad. That they have said, but if you mix this dissenting judgment and the majority judgment, then you will see this. The court is unanimous that dissenting in favor of government, intention can be taken from Justice Nagaratna's judgments. I mean, the dissenting judgment, and the rest of the things can be taken from the majority judgment and put together. 4+1 is equal to 5. Then, like 5-0 penalty shootout, the government has won. So that was a very curious part of dissenting judgment. I think that was unnecessary also for her to say, because how could a court judge the intention of the government? Court can only judge on the basis of legality and the facts before it. And of course, there are various other judgments which lauded previous governments' policies, etc. But in this case, intention is not the. Even the petitioners said that they are not going to the wisdom of what the government is doing. They are on legal grounds. But there is this comment from the dissenting opinion is actually that should be taken note of by those who view this judgment politically. That is my opinion. People can have different opinion. It is not as if I am passing a judgment on the Supreme Court judgment. I am just saying my opinion. Other opinions are also welcome. Yes, Arun.
Yes, sir. I think we have run out of time. Shall we open up questions to the other participants? And if anyone wants to present their view, they can.
Yes. Before that, I would like to say that you can ask any question related to the demonetization judgment, not the goods and evils of demonetization, about the judgment only. But bear in mind that we may not be able to answer some of it because we may not be equipped with all the answers. But certainly we can try to answer you. So one by one, you can raise hands and we will allow you to raise your questions or views. Yes, sir. One person has raised hands.
Yeah, hello. I just wanted to make one. You can hear me, right?
Yes, sir. Yes.
Yes, I just wanted to make first one observation regarding any and all. From my perspective, all actually is a subset of any, right? So if the word any is used, it does include all. And I hope that this, when it was mentioned in the majority judgment, that all equals any, I hope this is only with reference to this particular case. Because depending upon situation, it can be construed in different ways. Now, one question I wanted to ask is not exactly related to this demonetization thing. There was a mention by the judges, like you people mentioned, we are not experts and we don't wish to go into this financial aspects of these things. Now, there's a problem here if this is the kind of thing like when like judges come up with, because what happens here is you are leaving, loopholes in the justice system where subjects which are not generic, like financial system, high technologies, from there, people can actually get into criminal activities and judges will not be able to go into those situations. So doesn't the court system have consultants in different areas which requires a much higher level of knowledge so that they can actually advise?
Thank you, sir. Thank you, sir, for your question. In fact, this not going into the expert areas is related to the kind of jurisdiction the court has. Like the court is in a writ jurisdiction. The writ jurisdiction is not a factual jurisdiction. Like in the sense, if you put it like this, all these things about demonetization, the wrongs and rights of it, and the positives and negatives negatives of it are all fall into this factual realm. So
Right.
this is in this context that the court said that it is not going into the expert area. But
Okay.
as you pointed out, it is right that the court should, like in trials, in criminal trials,
Right.
court should have that expertise also. Like
Yes.
it is not like saying that investigation is the master of everything. Of course, police is the master of investigation, but the court should also be equipped with this kind of expertise also, what the investigation do, because after all the court is judging the how the investigation goes or whatever the matter. I'm just pointing out the example.
Yes, sir.
So you are right in that sense that the courts should also be equipped with such kind of information and such kind of ideas about those subjects which come under it. Come under it. But in this context, it is about the writ jurisdiction. Writ
Right.
jurisdiction, it is well settled that it cannot go to the expert areas of government,
Okay. Okay.
like in this case.
Right. Thank you very much. Thank you.
And I may add a point here, sir.
Yes.
One thing is that they say that we are not expert in deciding, in passing a comment upon the wisdom of the policy. Here, the wisdom means the policy should be made by the legislative, the people elected by us. The
Okay.
court themselves have admitted that the expert opinion differs. Let's say that the court has an expert on economy to advise them on this particular matter, and if their expert says opposite to the what the government says, then this should prevail. That would be a constitutional crisis, because the powers are clearly democrated.
That is true. That is true. But a court system, particularly when, let's say, in this case, finance, or maybe if I'm talking about even medical, like this, what happened in the case of recently this pandemic thing. If a court or people or consultants to the court, if there are any, I'm not very sure about that. If they are not aware of the details of the particular discipline they're going on to or into, they can be actually very easily fooled. Crime can get passed through the system without the judges being aware of it. That is what I'm trying to say.
Yes, I see your point. In criminal law, it may happen, but here, since it's a question of policy, then they can't have their own expert, because it is for the legislature to decide which policy should be carried out.
Oh, thank you. Thank you.
Another person has raised his hand. Yes, sir, you can speak.
Am I audible?
Yes, yes, please.
Firstly, sir, one question I would like to raise is that in this case, I think it is about the notification, or I would like to say the recommendation that RBI had to give to the central government under RBI Act. But what happened here, that the central government first asked the RBI to give us the recommendation. Directly or indirectly, but that is the point. I think that is the point of that should have been debated very well. It was not debated really well and discussed in this case. And another question that was I would like to just kind of a suggestion regarding this point that we were discussing, that whether expertise is required in every field or not. The point that I would like to raise is that in cases of freedom of religion, Supreme Court sometimes acts as a clergy. While it is not an expert in a particular religion, be it Islam, Hinduism, Buddhism, it is not expert in that religion. But still, many cases have come up where Supreme Court judges who are experts in the legal field, not in that religious field. They have given their views on the particular religion. So I think we need to bring some jurisprudence in that aspect also. Okay, thank you. That was the 2 points that I had to raise.
Thank you. Regarding your second point regarding freedom of religion and how can court go into the religious practices, etc., we will have another debate. But just for the point of answering you, I would say that this is already being considered by a 9 judges bench in Shabarimala review. They are answering all these questions, how much the scope of a constitutional court to go into these questions, etc. In the courts of, as you rightly pointed out, it's an area of expertise. Like religion is an area of expertise of religious people. So this question is being considered by the larger bench, nine judge bench, I believe. Yeah, 9 judge bench. And regarding your first question is regarding the origin. In fact, I would say that the entire judgment revolved around this origin issue. But it is being discussed in somewhat middle. There was no direct issue in this. But regarding the decision process, the court said that there was a communication between Arun has pointed out, and also I have also pointed out that there was a communication which went between RBI and the central government in this regard. The court said that this could not be like a situation where RBI ultimately the government has the power to demonetize, and it should be based on recommendation. Both are there, and this recommendation should be in consultation. That is how the court has justified this process. And we may agree or disagree with this view, but ultimately it is the Supreme Court judgment which has happened. That I will not agree with you to the extent that saying that it is not dealt with. It is dealt with, but we may not agree with that according to our logic. Yes, sir. Koshi sir is raising hand. Unmute and speak. Koshi sir.
Can you hear me? Hello.
Yes, sir. Yes, sir. Please.
Oh, okay. My doubt is from the point of view of a common man, as a layman. See, this withdrawal of, freezing of the currency had a devastating effect on the people of India, especially on the common man. As you said, you had some personal experience. You may not perhaps realize the full effect of it because you are a man of means to for sustenance. There are lakhs of crores of people in India who do not have any means of sustenance other than what they earn daily for their daily bread. So for such people, they were literally thrown on the streets before the ATMs and had to suffer a lot. And many of them, their lives became a misery for a long time because of this what you call a unwise decision. And regarding the wisdom of this decision, perhaps it may not be proper for us to think about that. But was there any wrong intention behind that? That is a question to be examined, in my view, because the proposal came from the government. It should have been the other way. The proposal came from the government, and the RBI, without any thinking on that, without applying their mind on that, they simply agreed to that. So that way only the decision came. So there is something to be something fishy in that. And another thing I have to say is this decision involves a lot of violation of human rights. The Supreme Court was sitting in judgment on that. Does the Supreme Court has a responsibility to think about the far-reaching human rights violation that are involved in this devastating decision of the executive? And did they go into that? Or could they go into that? Thank you.
Yes, sir. I in fact, I may not agree with you, but I respect your views regarding what you have expressed, and I know the difficulties it is not proper to say that if I am a man of means, then I will not know how people will suffer. It may not be proper for you to say that, but as I pointed out earlier, this discussion is not about the evils of demonetization. I have uh, I have already told you, in the sense we know each other uh, for the purpose of information. The speaker just spoke now, and myself know each other for a very long time, and you know that I also have told you that there are quite a disaster that has happened post demonetization. But this is not a forum for we discussing that, because we are discussing the judgment which actually went into the questions, went into the legal questions which are raised by the petitioners in this case. I will end with that, but I respect your views in any case.
My question, my doubt actually is whether the Supreme Court, being
I heard that question.
guardian of the Constitution
I
and
heard that
the
question. I heard that question, but I deliberately chose not to answer it. We can have it in another forum. But that question is kind of an, in my view, in my respectful view, that is kind of an emotional argument you are making, or emotional question you are making. In this case, the court was concerned only with, I believe, 5 or 6
on
questions.
that only, Mr. Ashok, on that point only my doubt rests, because
Yes, I am.
could the
I am
could the
answering that. I
could
am answering that. Let me answer that first. I am answering that by saying that this is an emotional question. You can judge me in any way. You can say
no,
that
this
I
is not
am
a
skipping.
dispute between us.
I
No,
am skipping. I am skipping
I'm
this question intentionally. I am skipping this intentionally because the scope of this discussion is not about effects of demonetization. I have made it clear in the beginning. It is only about what the judgment said. So I'm sorry that I could not answer you. I would answer it to you in another forum, but not now. Thank you.
But can you answer this particular point? Because could the Supreme Court have expanded their powers and gone into into the merits of this issue, at
I do
least for
not
the
think that
future?
I do not think that that would be a proper way for the Supreme Court to do now. It can be done in 3 judges benches. Like this was a bench which was handling some certain questions raised by 3 judges bench. These questions have been answered in favor of government by issues as answered in favor of government, and those issues, after having answered it, have been referred back to, writ petitions have been referred back to the 3 judges benches. Still, it is alive. Writ petitions are still alive. People who have actually suffered uh, these human right violations, as you allege, as you point out, as are already before the court, and it will not be proper for me to say that Supreme Court should have done this and done that, etc. But I believe that this may be addressed by the 3 judges bench. Whatever difficulties happen, whatever devastating results happened, might be in a proper way answered by the Supreme Court itself, not me.
Okay, sir. Thank you.
Thank you, sir. Yes, one more speaker is there. One more hands have been raised. Mr. Vinu.
Yeah, hi, Ashok sir. Am I audible?
Yes, can it be a little louder? You are audible, but
Yeah, you hear me now, sir?
yes, yes, yes.
Yeah, mine is I'm a second year student. I'm actually Arun's junior, so my question could be a little naive, but I just wanted to ask you so that I can get perspective on how judgments are written, especially when it comes to constitutional benches. So forgive me if I go out of context a little bit, but the key thing is about how judgments are written based on evidences placed before the court of law, right? And in this case, I'm wondering on what basis there could be two judgments, like for and against, because I'll just quote what the Chief Justice has said, in the sense he said, and I shall quote him, that the details and evidences records placed in front of the court show that RBI was very much in the loop all through this. and for this demonetization move. If this is true, if the evidence is clearly pointed that RBI was in the loop and the central government wasn't pushing the RBI to make this move, then on what basis did Justice Nagaratna write the dissent? And this brings me to another layer of question, which could be a politically flavored. You can skip it if you want, but you had already touched upon it light in your second answer to Arun. So I'm thinking in the recent judgments that we see, right? When it comes to judgments like the hijab issue, the EWS 10% thing, the Ram Janmabhoomi, and all those constitutional bench level decisions or verdicts, I feel the dissents are not really living up to the uh, core of the constitution. In the sense, our current CJI, I have very high regards for him. He says dissenting judgment is the heart and soul of a democracy. From this point of view, these split judgments that they come will still go in favor of the ruling party. Am I only the one who's making this observation, or am I wrong in thinking in these lines? Can you just enlighten me, sir?
Yes, we know this is a question. This is quite a good question, but I think it will not be proper for me to answer it here. But regarding the demonetization aspect, you have pointed out how can there be two views. I believe that Justice Nagaratna and Justice Gawai differed in view of interpretation, and you rightly pointed it out, saying that there was 6 months consultation between the RBI and the government. That observation is made by the majority judgment, but Justice Nagaratna says that there was only 24 hours gap, 24 hours between how the government asked for an advice, asked for a recommendation, and RBI gave it within 24 hours. So there is quite a mismatch there, but that may be due to the perception of things. Facts might be same for all the 5 judges, but she might have thought that the communication which the majority is talking about is not to its fullest. Maybe it is only formal thing. It might be in her perception that that is not a full communication between the government. There is no consultation, etc. And she skipped that and said that this is only 24 hours. That could be the point of difference between on factual grounds. On legal grounds, there are dissenting judgments. And in fact, we famously know ADM Jabalpur judgment by Khanna, Justice Khanna, became majority later. There are other judgments which become a majority later. That can happen. But on factual grounds, this does not happen. On legal issues, majority judgments are equally important, or vice versa. Dissenting judgments, dissenting opinions are equally important as majority judgment. For the progress of law in that area. Now, as you pointed out in hijab case, etc., there is a split judgment. There is a split judgment, as you rightly pointed out. It is in favor of the ruling party or whatsoever administration. So, regarding split judgment, we can have a different talk altogether. That is an interesting area of split judgments. For as of now, I would end by answering like this.
Yes, sir. Thank you, sir.
Yes, well, I think we can take one more question. Yes, someone has raised hands. Advocate name is not shown. Yes, please, you can speak.
Hello.
Yes, sir. Advocate Dharmendra. Yes, sir. You can speak.
Sir, thank you to give me this opportunity. I just wanted to point out that there is a tendency now we see in media that 4 judges giving some judgment and 1 judge is dissenting, and most of the time 1 judge who is dissenting is shown to be correct by presenting it so in the media to the people. Every time they think that the dissenting judge is more right in comparison to wisdom of 4 judges. Sir, my only question was that during the talk you said that the dissenting judgment, the judge who gave this dissenting judgment She said that there is no question regarding intention of the government. There is only question regarding the legality. Uh, in what sense she was saying that there is question regarding legality, and how come this can be connected with the executive's power through ordinance to bring in anything if there is a sense of urgency to bring in any kind of decision to do something which is in the interest of the nation. Like if it is their political decision, their wisdom that this is something which is required at this moment, and they are doing it all of a sudden, say even in 24 hours, which is a requirement in certain issues. Some decisions have to be taken quickly. You cannot simply announce them publicly and then bring it in. So, in what sense specifically dissenting judge said that it is illegal the way this thing is executed?
Sir, unmute yourself.
I'm sorry. I would answer it like this. Justice Nagaratna's judgment is has taken a quite different view about legality of demonetization. According to her, as you rightly pointed out, ordinance or legislative route. She said that the ordinance and legislative route could very well taken. That was her point of dissent. She did not say that no, the government should not demonetize these currencies. Government has no power to do that. She did not say that. She said that 26(2) does not give the government the power to demonetize all series of particular denomination, like all 500s and all thousands. She said this could be done under the schedule, like it's a union's legislative power to do certain things regarding the currencies. So it could be the government could take the legislative route or the ordinance route. In fact, every legislation, if it is urgent and the parliament is not in session, ordinance can be given. So ordinance route was still open, but government did not take the ordinance route. It did not take the legislative route. That was justified because the legislative route would take a quite time, and since this decision has to be done in secrecy, or what they call secrecy, or in quite hasty manner. So Justice Nagaratna's judgment does not say that government has the power to demonetize, but it said that the route adopted was wrong according to her interpretation of 26(2), not that it does not possess any power. That is the spirit of dissenting opinion, and I would say that I have already pointed it out that after all saying all this, it was not necessary in my view to say that intention was good, etc., because she was not examining, court was not examining the intention or the whatever good and bad of demonetization. That is my point of view. Thank you.
Thank you so much, sir.
And I may just add here, and the majority judgment said that we are not experts to comment upon this. And Sir said we do not understand why she comment upon the wisdom of this policy, the demonetization. That's beyond us. That's even confusing to us.
Yeah, so we think we can wind up this very first session. I think about 20-25 persons have attended. A dozen people have heard us on Twitter as well. I thank you all for being with us. Some questions are not answered for reasons we thought is relevant. I apologize if we did not satisfy the what you say, Arun. If we could not satisfy some aspects of questions, we apologize for that. We will improve. This is our first session, and I think that we should meet quite often in weekends regarding small issues like a provision of law or a particular judgment which should be known to all. Like say what Arun does in YouTube is Lalita Kumari judgment, or Shreya Singhal judgment of 66A, which is not yet known to the executive after so many reiterations, etc. We can have such discussions in future. I will inform you in WhatsApp, and also Twitter, and also everywhere where we have forums. I will inform the future date of discussion. I request you to be part of this. And now we are winding up the very first club discussion of CiteCase. Thank you very much. Thank you.
Thank you, sir.